Feeling lost in the maze of CPS? Desperate to get your child back? You're not alone. Countless parents face the heart-wrenching reality of family separation. The legal system can be overwhelming, but there's hope.
Now, here's the key. Okay, that's how you win a 6-month hearing.
Thank you.
If you do all of those things, you're going to blow your social worker's mind, you're going to blow your attorney's mind, and you're going to blow away the judge.
With attorney Vincent W. Davis, a dedicated legal expert with 39 years of experience, committed to helping families like yours. Join his weekly live Q&A on Zoom, where you can ask your burning questions about CPS cases. Get the knowledge and strategies you need to fight for your child's return.
Alrighty, good evening everyone. This is a question and answer session.
Are you ready to take control of your family's future? Participate as a one-time guest. Don't let fear hold you back. Take the first step towards reuniting your family. Join us now.
All right, good evening. I'm attorney Vince Davis. I'm here with Miss G, and this is our office hours for CPS. Good evening, Miss G.
Good evening. How are you today?
Good. What are we going to talk about during office hours tonight?
Well, as we promised last show, we're going to start talking about the different hearings from your book. Let's start with the 388 petition and what is required with the 388 petition, because oftentimes people think it's just a one-page form. It's not. It's a lot of work involved in that. And I had actually a couple of attorneys that called me last week and asked about your book, in fact, and they wanted to have a consultation with you. But unfortunately, you had hearings the whole week. And I told them that you're booked the whole week. And they said that they're going to try another time to set an appointment with you so you can explain to them how to win cases, CPS cases, because they're not really seasoned. One was doing it for only 2 years. The other one is doing it for 5 years. So I realized that people need an education on the types of hearings that you listed in your book, and to educate them. But since I've been with you in court, I know that it takes way more than that. It's not just what you put in writing, it's also the presentation in court. It's also, right, what you do in court that matters.
Okay, 388.
Mm-hmm.
In other states, it's called something else,
Right.
but I believe most states have what's akin to a 388 petition. In California, we call it Welfare and Institutions Code Section 388.
Mm-hmm.
It basically is a get out of jail free card.
Mm-hmm.
So if anyone wants to change a current court order in California, you can file a 388 petition.
Mm-hmm.
Okay. And generally, they can be filed at or after the disposition hearing in California.
Mm-hmm.
Now, there is a mandatory form you have to use that's published by the Judicial Council in California.
Mm-hmm.
It's a JV 190, or you can just Google 388 form and the PDF will come up, and it's a fillable PDF and you can just type the information in.
Okay.
It's actually a 4-page form and it's self-explanatory for the most part.
Mm-hmm.
All right. Now, I have seen people fill out this form incorrectly. And the thing that gets people incorrect filling it out is the change of circumstances and the best interest aren't clearly articulated in the 388 form, in this 4-page form.
Mm-hmm.
But, and this is where everyone goes off the rails, you have to file, in my humble opinion, more than that 4-page form.
Mm-hmm.
You have to file declarations from witnesses to support your 388 requests and, videotaped evidence if you have it. And you have to file what's called points and authorities, legal points and authorities, where you show the judge by the facts you have in your evidence why your 388 should be granted. Okay? So, folks, unless you have some legal training, unless you have experience doing these 388 forms, it's not going to be granted. Likelihood it's not going to be granted. Okay? So you got to have some help, in my opinion, filling out these forms, adding the declarations with evidence and exhibits, adding the legal points and authorities. Now, you can slap together a 388, and if it gets granted, you're going to get, lucky, which doesn't happen all the time. And I'm getting the opinion or feeling that a lot of 388s these days aren't being granted liberally like they used to be, or liberally like the Court of Appeal says that they should be granted.
Right.
Now, when they're granted, they're only granted usually for one reason. They're granted for you to have what's called a prima facie hearing. Okay? That's where you get to go to court and face the other attorneys and the judge, and you get to argue, and they get to argue against you on why you should have a 388 hearing, a real 388 hearing. So prima facie means you have to go to court and convince the court that you're entitled to a trial on another day. Okay? Now, at that hearing, the judge could rule against you and say, Mr. Davis, you haven't convinced me. You don't get a prima facie hearing. Now, the 388 could have just been denied without a prima facie hearing. But say I file a good 388 and the judge says, okay, you can have a prima facie hearing. I go to court and some other attorneys decide to argue against my 388, and they convince the judge that I shouldn't have a full-blown hearing. And the judge denies it. Or I convince the judge to give me a full-blown hearing. The case is generally continued to another day, and there is evidence presented at what's called a contested hearing. It's basically a trial where witnesses are called, and if it's your 388, you have the burden of proof. Witnesses are called, they're cross-examined. Other parties, like the social worker, get to call witnesses, get to introduce their reports into evidence, right? And by the way, hearsay still applies for the social worker, right? So you have to overcome their evidence, and you get to cross-examine, witnesses, and you get to subpoena in witnesses to be cross-examined or direct examination by you. And then the judge makes a decision. So that whole prima facie and contested hearing is about 50 to 60% of getting a 388 granted. A lot of people think that the 4-page form, the JV 190, is 100% of the 388. It represents maybe 25% of the 388. The other 25%, or the other 20%, represents the declarations and the evidence and the legal points and authorities. So if you just file the JV 190 and think you're going to get something granted, the odds are that you're not going to get it granted. Or if you do get a prima facie hearing and you get past that, when you go to the contested hearing, you still have to prove a case with evidence and, witnesses and documentary evidence and things of that nature. And don't forget, most of the time, the social worker and her attorney are going to be against you. you have to present evidence. You can't go to the 388 hearing and argue, because as I've said in many videos, attorney argument is not evidence. If you go to a contested hearing, no matter what type of hearing, and you just argue 999 times out of 1,000, you're going to lose. So don't show up to a gunfight without a gun. You need evidence, you need witnesses. You need to know how to get documentary evidence into court, into the evidence, so the judge can consider it. All right?
Mhm.
I'm not going to tell any stories because Miss G doesn't want to tell me any stories tonight, but you better talk to your lawyer or talk to a lawyer and figure out how to get pieces of paper into evidence, because you just don't show up and say, here, judge, enter this into evidence. It doesn't work like that. Okay? Even if it was a document you attached to your 388 as evidence, that doesn't mean it comes into evidence at the trial or contested hearing. You still have to move it into evidence the right way.
Mhm.
All right. So, Miss G, do you have any questions about what I said?
Yeah, Stoned Tarot said, if you lost your parental rights and it's long after your disposition hearing, then how do you file a 388?
Okay, 388 actually says any person can file a 388. So the man standing out on the corner can file a 388. And presumably a parent who's lost their parental rights can file a 388.
Mhm.
I actually know of a case in San Diego County where a woman who lost her parental rights 5 years later filed a 388 and got her kid back and got her parental rights reinstated.
Mhm.
Now, the stars had to align the right way, but it happened. Any other questions, Miss G?
Yes. What advice do you give parents who already have a court appointed attorney? And I'd like to call them court pretenders, that don't want to file a 388 and tells them that if they file a 388, the judge will deny it. What would you tell parents who have to deal with this day by day?
Well, I would tell them probably seek a second opinion,
Mhm.
because sometimes, the 388, it's can be extra work, right?
Mhm.
And seek a second opinion. Maybe you want to get a 388 prepared and give it to your attorney to file for you,
Mhm.
right? But somehow and sometimes you got to get that 388 filed.
Right.
Okay.
Okay. What if their attorney tells them they're going to lose if they file a 388? What, I guess, getting a second opinion, I'm sure you would tell them to file a 388. What if their attorney doesn't want to do it? By them getting it prepared and their court pretenders don't want to get it done, what chances does she have, like for this young lady right here, this young mom, what chances does she have if her parental rights was already terminated? See, that's
Well, hold on. Well, this lady right here, if her rights are terminated,
right.
she doesn't have a court-appointed attorney. So
Oh, okay.
she's going to have to file it on her own.
Right, but she had a court-appointed attorney. She
Yeah,
had.
but it's over. Okay, she doesn't have any parental rights, so she doesn't have a court-appointed attorney. If she wants to file a 388, she's going to have to do it on her own, or she's going to have to hire an attorney.
Okay. Okay. Now, when so you said the 388 requires a lot of work. Can somebody do it on their own with your help? Can a mother or a father, or a parent in general, do it on their own with your help instead of getting you to represent them in court?
Yeah, they could.
Okay, but is it going to be an easy steps for them? Because most of them are emotional, as we know.
Well, filing the 388 with my help
Right.
is good. Their problem is going to come when they go to the prima facie hearing or the actual trial, I won't be there if they don't hire me.
Right.
So then they're going into, 55% of the case
Right.
without a lawyer. See, a lot of people think, well, and I know this because people call me and say, well, if I file the 388 and it's granted, I win. No. If you file a 388 and it's granted, that only means you get to have a hearing. That's all it means.
Right.
Now, at the hearing, that's like a mini trial. You got to present evidence. You got to cross-examine witnesses, direct examine witnesses. You got to do closing argument. Most people don't know how to do that if they haven't, if they're not a lawyer and they haven't had experience in these types of cases.
Right. What do you think about parents who hire, instead of a CPS defense attorney, they hire a family law attorney or a criminal attorney for CPS?
Well, if that attorney doesn't have any CPS experience, it's not the optimum solution.
Mm-hmm.
But it's better than not hiring an attorney. But it's definitely not the optimum solution. It would be like someone hiring me to do a patent case. I don't know anything about patents.
Right.
And even if I tried to learn, it wouldn't be the optimum situation.
Mm-hmm.
You might as well hire me to do brain surgery.
That's true. And you don't know how to do that either. So
I could Google it. Right. You see how ridiculous that is?
Yeah, it's so ridiculous. I can't picture you.
It just made you laugh. Right.
Surgery at all.
Right.
Yeah. But I'm glad you addressed that issue because I do get a lot of calls about that. And it's so important. Even when as you see, I have like highlights in your book. I try my best to explain it to them. But they still don't get it. Even though they have the book, I explain it to them as you taught me in the past. But it's a complete different world. I tell everyone I've been to court with you. In fact, I'm going to court with you again this Wednesday. And it's a complete different world in court. You don't act the way you act here. You're completely different in court, right? You're more focused on the topic. You don't let them distract you. You don't allow them to distract you. You're focused to the point where the judge questions herself. And actually, the judge questions the social workers as well. Kind of like, let me check on that. Because some of the judges don't even know the law, believe it or not. Because
when you go to court, it's your job to be an advocate and try to persuade the judge or the jury. In this case, it's a jury of one. It's a judge.
Right.
And that's your job to try to persuade the judge to your point of view.
To the truth, really, to the facts. Because you can't persuade the judge when you're wrong, but you can persuade the judge when you have facts. Am I right?
Well, yeah.
You pause there for a second. You're like,
You want to persuade the judge to your set of facts and to your interpretation of the law.
Okay. Interpretation of the law.
Right.
Interpretation of the law.
Right. That's the funny thing about the law. Everyone thinks it's black and white, and it's not.
It's not.
It's a whole lot of gray. There's a little black and white, but it's a whole lot of gray.
Okay. What else can you tell them about the 388 at all? Any other points you want to throw out there regarding the 388 petition? Can grandparents file the 388 petition?
Look, anybody can file a 388.
Right. You said that.
But that doesn't mean you're going to win.
Correct.
Right. And a lot of times people that file 388s, this is probably the most important legal thing they're going to do in their life.
Right.
And they really want to take that chance.
No.
You and I, a couple of weeks ago, talked to some grandparents about getting their grandchildren placed with them. And they, were going to file the 388. It's a one-time shot. And I kind of shook my head because, I know that the odds are against them.
Very.
I talk to a lot of people because this is America and they believe that the judge is going to do the right thing. The problem is what they believe the right thing is different from what the judge believes is right and what the social worker believes is right.
That's true, but oftentimes the judges don't even know that. I have seen you in court where the judge, and I think I mentioned that before, where the judge actually questioned herself. And she had to leave the chair and to go to her office or chamber, and she called other judges to make sure you're right.
You don't know if she called other judges.
But she came back and she said, I discussed it with my colleagues. So who all her colleagues?
I don't know if she said that. I don't remember.
What did she say? That was in Sacramento. The judge in Sacramento.
I don't remember.
Left you. She went, I guess, to her office. She came back and she said, you were right. You actually mentioned that in the show last time. She said you were right.
Oh, that wasn't Sacramento.
Oh, which one was it? I've been to so many court hearings, I can't remember anymore.
That wasn't Sacramento.
Yolo County? Which one was it?
I'm not going to mention the county.
Oh, okay. Well, the judge did say that you were right. And the attorney, the social worker, the children attorney was pissed. Like, I can see the expression on her face. She just wanted to literally hurt you. And all of their mouth was open, all of them. I know you remember. You have to remember that. Because
I remember it
that day. Yeah,
I remember it.
And that was to redo the jurisdictional dispositional hearing. Remember?
It was a dispositional hearing.
It was also a dispositional hearing. Yeah, It was to do it again because the way they did it was.
No, what it was, and I don't know, because I get strange looks all the time when I bring this up at dispositional hearings. That if a child's in foster care, the test for not giving the child back is the social worker has to prove by clear and convincing evidence, which is very high standard, that the parent is a substantial danger, not a risk, not a substantial risk, a substantial danger to the child. And there's no less restrictive alternative. There was a case that you came with me on, and I asked the social worker, I said, hey man, what less restrictive alternatives did you consider other than foster care? And he kind of looked at me and then he said, none. None? You didn't consider any? Theoretically, I should have won right there. But the case went on another day and a half because I had to prove more, right? But he didn't meet his burden. If I had the balls, I should have just argued right there, hey, he didn't meet his second test by clear and convincing evidence. And I ended up winning that case because I actually put the grandmother on the stand and I said, hey, grandma, if the judge releases the kids back to the mom, will you live in the mom's house and watch the mom and keep the kids safe? And she said, yeah, I'll do that. And the judge latched onto that and said, oh, that's a less restrictive alternative. And it is. It is.
There's another.
Anyway, let's get it back to the 388. So any other questions you have about the 388, or are office hours over?
This is not about the 388, but I do have a mother that called me today. And this is just for you guys out there if you're going through the same thing. Her case was closed last year in 2024. And the kids were never removed to begin with. That's an LA County case. And the social workers were not happy. The judge told her in court, and she has the court documents stating the case is closed. That's it. Done. So her attorney told her the case is closed. You don't have to continue to do the therapist classes. This is on you. If you want to continue to go or not, that's on you. All of a sudden, a week ago, social workers came to her house and they said that her case is not closed, that the judge did say it's closed, but that doesn't necessarily mean CPS closed the case. Is that true? Because they're harassing her. They want to do a home check. even though she has proved that the case is closed. And one of them wanted to come tonight at 7 p.m. He's an investigative social worker. She called her attorney that handled the case before. He said, do not talk to them. And with her silly self, she ended up talking to them. And
she should call me. There's a civil rights case lurking there somewhere.
Yep, I told her that. I said
when the judge says the case is closed,
Yep.
It's closed.
It's closed.
Finished.
That's
done.
It's done. But the social workers are trying to, of course, obviously they lie so much because they want the money. The money, follow the cash. You'll see social workers. But they're harassing her. So now they're going to open a case with false allegations against her because they're not happy with the outcome. The judge closed the case.
That's not unusual.
Mm-hmm.
When social workers aren't happy with the judge's decision, they find an end run around it.
Right. And she asked me if they can do that. I said they can do whatever they want because nobody's holding them accountable. That's the problem. Nobody's holding them accountable. And I told her they don't have full immunity, but they do have partial immunity.
Well, they have qualified immunity.
Oh, qualified immunity. Okay.
And that means in order to sue them and win, you have to prove that they acted with malice.
That is malice. That has to be malice.
Arguably, I believe that you would be correct.
Yeah, it is malice because a lot of social workers feel that they're untouchable, but they're touchable. I can touch them.
One of the things that's always been considered malice is a social worker lying, in a report or on the stand. Mm-hmm. But there's a case out of Orange County, and this is actually on YouTube in the Ninth Circuit Court of Appeals, the federal circuit that we live in. They publish on YouTube all of their oral arguments. Mm-hmm. And there was a case, I think it may have been out of San Diego, but there was a case where, a couple guys I know sued the county. And what happened was the social worker lied. And the county argued that lying should be covered by the qualified immunity, right? And they actually sent a young lawyer to argue that in front of these three very experienced federal judges, appellate judges. Mm-hmm. And they weren't having it. Nope. They weren't having it at all. And they were kind of...
They were mad. They were actually mad.
They were shocked that this attorney would argue that a social worker should have immunity for lying on the stand or in a report. Mm-hmm. And if you guys are on YouTube, you should look that case up.
It's like almost 2 hours run. Yeah.
Because it was, but it just goes to show you how far they will go to try to protect social workers. Now, you would think that if you raise your right hand, just swear to tell the truth, the whole truth, and nothing but the truth, or you sign something under penalty of perjury that something is true, that, there should be consequences. Mm-hmm. But yet and still, they're trying to argue that, no, we're trying to protect children and you should let us off the hook.
That's not even.
And the judge said, no, that we're not going that far.
Yeah, but they still do it, Vincent. There's no changes. They still do it. I mean,
what happens
is they hire newer people and they're younger people. They keep getting younger and younger. And in fact, those people literally will do anything to keep their job. And a lot of them know what they're doing is wrong, but they keep doing it because it's called job security. Okay, that's what it is.
I think you're partially right, but I think that they have been convinced that they are doing God's work to protect children.
I don't know what God they're believing in, but the devil is called God do. So,
but I actually believe that. I actually believe that some of these people have been convinced that we should do anything in the world to protect these poor children.
Oh my God! But it's common sense. It's common sense, right?
To you and me. To
either
you
work
and me.
of God or work of Satan.
Do you know anything? Do you know anything about cults?
Yes, of course.
Right.
They're cults.
Some people believe that these are cults.
Yep, they are.
They have certain characteristics of cults.
Mhm.
right?
They're bullies too. They bully parents. This woman is being bullied by this. The woman I just mentioned, the mother I just mentioned today. They're forcing her themselves on her. They're bombarding her with calls and calls and calls, one after the next. I mean, they're literally harassing the mother. The kids are not abused at all, and she can't process, understand that. And then the social worker told her that the kids should know their father, but the judge said the father is dangerous. So therefore, why do you want the children to know their father if the father is abusive to them? So the worker said the kids need their dad. Why is it always the abuser always wants to be handed to the children to? That's one thing I never understood, and I feel like it's a manly role.
Hold on. We're going far afield. Tonight's office hours on 388.
I'm sorry, but this woman really got to me because this mother and
Do you have any more questions on 388?
No, I don't.
If you don't, I'm going to end office hours.
Okay, fine.
All right.
So tomorrow, wait. Our next show is going to be, hold on. And I want Grace to make a mental note of that. The first hearing, the arraignment and detention hearing, okay, which is called A and D, okay, hearing.
You know, I wrote a checklist for the arraignment detention hearing. And tomorrow, for everyone that attends, I'm going to post. No, that's my book. I did a separate.
I know. This is what we're covering.
I did a separate checklist that you should probably have and go over with your lawyer before the arraignment and detention hearing. And I'm going to post that tomorrow in the comments. And if you are watching tomorrow, you can click on it and download that PDF and have that checklist.
Can we do are we going to do the show around the same time, or are we going to do it earlier?
I don't know.
Okay. Well, stay tuned, guys. Grace is going to post it.
Yeah, by tomorrow at noon, we'll know, and Grace will post it on the 8 social media sites that we have on Facebook and YouTube.
Yeah, because I think your calendars.
And then if you don't catch it live, you won't get I guess you won't have the link. Oh no, they'll still have the comments. Mm-hmm. So you can, if you don't catch it live,
be able to answer questions, get questions answered.
Yes, but if you don't catch it live, it'll be in the link, on YouTube or Facebook,
right,
or wherever, and you can still get the PDF.
Okay, guys. So the first court hearing, the arraignment and detention hearing, is the A and D. We're going to cover that tomorrow, God willing, and we'll let you know the time when Grace posts it.
Is it your plan to go through every hearing? Do a video on every hearing? Okay. All right.
Yeah, where people can also ask questions and comments. I want to address all the comments, just like Stone Turret did. I want you to try to answer all the questions, so that way they know what they're getting themselves into. I think that's very important. That's what parents want. They don't want to really hear other stories. I've noticed that a lot of them said, no, we don't want to hear other people's stories, because we want to know what we're going through and be able to answer their questions. That's what they're looking for.
Okay. Sounds good.
All right.
All right. See you guys tomorrow.
All right. Good night.
Bye-bye.
Bye-bye.
Feeling lost in the maze of CPS? Desperate to get your child back? You're not alone. Countless parents face the heart-wrenching reality of family separation. The legal system can be overwhelming, but there's hope.
Now, here's the key. Okay, that's how you win a 6-month hearing.
Thank you.
If you do all of those things, you're going to blow your social worker's mind, you're going to blow your attorney's mind, and you're going to blow away the judge.
With attorney Vincent W. Davis, a dedicated legal expert with 39 years of experience, committed to helping families like yours. Join his weekly live Q&A on Zoom, where you can ask your burning questions about CPS cases. Get the knowledge and strategies you need to fight for your child's return.
Alrighty, good evening everyone. This is a question and answer session.
Are you ready to take control of your family's future? Participate as a one-time guest. Don't let fear hold you back. Take the first step towards reuniting your family. Join us now.